Good day to you and welcome to another Paddocks Club video tutorial. Today I want to concentrate on prescribed conduct rule number 5, the one headed appearance from outside. The wording of this rule is the owner or occupier of a section used for residential purposes shall not place or do anything on any part of the common property, including balconies, patios, stoops and gardens, which in the discretion of the trustees is aesthetically displeasing or undesirable when viewed from the outside of the section. So this is a situation in which you're stopped and prohibited from doing something which the trustees consider to be aesthetically undesirable. In other words, it reduces the aesthetic appeal, the visual effect of the scheme is prejudiced by this thing that you're doing. First comment, the rule can be altered by the developer on the opening of the sectional title register and thereafter by special resolution of the body corporate. Very often this type of conduct rule is changed. So when you come across a new situation in a scheme, best to check the conduct rules and just make sure that this one is either in as prescribed or how it's been changed. The reference to common property in this rule also, I just mentioned, will include areas of common property that are subject to exclusive use rights, so that it doesn't, this affects all areas of common property. Examples of what the trustees may consider to be unsightly are given by Professor Graham Paddock in Sectional Titles, his book on the subject. And these, he says, include items of washing or articles being aired or cleaned, window panes that remain broken for a number of days after they've initially been broken, and a generally dirty or untidy appearance. Well, I think one does have to bear in mind that there has been a change in the approach to air drying of articles of clothing, and many people will say these days that that is the most environmentally friendly way to do it. That's an issue that the scheme must take into account, and the attitude of the trustees generally perhaps should be informed by a direction given in terms of Section 39(1) of the Act if the majority of owners actually think that washing visible on balconies or on patios is not something that should be discouraged. In the case of the body corporate of the Cape d'Azur sectional title schemes v. Intercom Property CC, which you can see in the library, the High Court discussed a particular rule with the same wording as this, and it refused to enforce the rule because the trustees had made their decision without allowing the owner an opportunity to explain his position and without taking the aesthetic merits or demerits of the case into account. So you can't simply have a general rule. You've got to look at each instance individually. The trustees have to meet or at least discuss the thing amongst themselves one way or another and take a decision in each case. Because in this case, the court found that the trustees had failed to apply their minds properly to the decision and to the relevant facts. So you need a paper trail that before you implement a rule like this that shows you have thought about it, this particular case. Finally, I just make the point that it's clear from this case that you've got to hear the owner's point of view. You must make a reasoned decision that the placement or the action in question is undesirable or aesthetically displeasing before being in a position to give that owner or occupier a notice that you consider him or her to be in breach of the provisions of this rule. And it makes sense when you do that to actually give your reasons. Thank you for joining me in this, and if you have any questions, let's deal with them in the discussion forum.